Hello, this is John Milburn for Laws 11059 Statutory Interpretation for Central Queensland University. This is week 7 of term 3, 2017. Tonight we're dealing with chapter 7 of your text, and that deals with the topic of intrinsic materials within the text itself. Before we deal with tonight's substantive areas of practice, just a quick note in relation to the first assessment piece. I'm well advanced in my marking, and overall, from what I've read so far, I'm very happy with the standard of work. Most people have presented a document that is professional in its content and its overall presentation. Most people have clearly considered my sample document, and they've incorporated the AGLC in the way in which they have presented their referencing material. The content is good. There is a fair degree of subjectivity when it comes to determining the content, but overall, people have drawn well-supported conclusions based on what they say is the appropriate conclusion. All right, so in general terms, when you're arguing based on statutory interpretation, you need to be ready to argue a position. Being ready to argue is important. What I mean is that there's not necessarily going to be a right or wrong answer when it comes to the law. There are shades of grey, and sometimes you need to look carefully to even see the grey. You may need to be creative and inventive. You need to pursue an argument, and lawyers, of course, are very fickle. You may find yourself arguing the exact opposite of what you argued the day before. When you do argue, irrespective of the side that you're on, you argue with vigour. So your role is to argue the case. The court is there to make the decision, and the system works well if the court receives a capable presentation from both sides of the argument from opposing counsel. So I say that there's no right or wrong answer with some degree of confidence. Many of you have read of split decisions even in the High Court, or even particularly in the High Court, so that judges will disagree on what is the appropriate conclusion, even though they are consistently considering the law in an appropriate manner. So be prepared to argue and advance your argument and support it well. All right, so all words have meaning. We know that. That's from Project Blue Sky against Australian Broadcasting Authority, 1998, 194 CLR. And a court construing a statutory provision must strive to give meaning to every word of a provision. That's one of the quotes from that case. That really is a go-to case when it comes to statutory interpretation. So I'd urge you to have some quotes ready to go and catalogue these things. Last week we spoke about issues to do with cataloguing information about individual words. So, for example, if you're talking about the object or intent of legislation, be prepared to explain to a court as part of your argument what you mean by the object, what you mean by intent, and how do you support these arguments. So you should have your own, if you like, dictionary that you prepare as part of your statutory interpretation toolkit. You should also have supporting provisions from legislation or case law, and if it's case law, preferably a particular quote referencing the paragraph or page from which that quote is drawn. So all words have meaning, and ordinarily the meaning is the ordinary meaning of the words. Won't always be the case, and sometimes it will be split. In other words, it may be that the ordinary meaning applies to some extent, but not always. So let's place ourselves in a situation now that highlights the importance of determining the ordinary meaning where relevant. Put yourself in this position. You're an advisor and a client comes to you and says something like, "I want compensation for injuries I sustained." Okay, well, that's fair enough. What happened? Well, I tried to get something out of my bag, which was on an overhead rack, and it was while I was a customer on a tour bus. So you stood up, you tried to get something out of the bag, and you sustained an injury. Yes, I was injured in the course of doing that. Have you tried through insurance? The insurance company says they'll not pay because they say that personal injuries, which I sustained, and the insurance policy that applies to personal injuries only applies where the person was wearing a seatbelt. Now, clearly, I was not wearing a seatbelt. I was trying to retrieve something in the overhead rack. Can I claim against the insurance company? The real case, as you would have read, is Insight Vacations, Pty Ltd, trading as Insight Vacations against Young. It's a High Court decision, 2011, 243 CLR 149. As an aside, just note the difference between a company and a business name. All right, so what did the High Court consider? It referred to the fact that ordinarily passengers do not have to be seated 100% of the time. Therefore, even though the exemption clause contained words with an ordinary and clear meaning, the ordinary meaning is the meaning of the words in the ordinary situation to which they refer. Because people on a bus, long-term bus trip, sometimes get out of their seats, perhaps to go to the toilet if the bus is equipped with a toilet, or, as was the case with your client, to get something from an overhead rack. That means that the exemption clause must be read according to its ordinary meaning. This means that even though the clause says the insurance policy applies only if a person is belted, that is seat belted, that exemption only applies if the passenger is also seated. So in that situation, the High Court was willing to add something to the policy that did not otherwise exist. Place yourself now as if you were the advisor from the outset of the matter. How do you advise parties in those circumstances? You say to a client, all right, the terms are clear. In order to claim on the insurance policy, you must have been wearing a seatbelt, and you weren't. Many advisors would say that's the end of the matter. But a brave, inventive advisor would say, yes, whilst those terms appear to be clear, there is an exemption to say that you cannot claim, they're clear, you can't claim if you're not wearing a seatbelt, but we could go into court and ask the court to incorporate an unwritten provision into that scenario. Would you be brave enough to do that? Would you be brave enough to go to the High Court and argue the toss? Okay, so what we can see from that decision in Insight Vacations and Young is that the court will consider the ordinary situation to which the words refer when determining the ordinary meaning of the words. Let's move on to a different scenario, and that is a scenario where there might be a technical or legal meaning used. The courts will make a presumption, this is a common law presumption, and that is that where words do have a technical or legal meaning, they will apply those technical or legal meanings when considering what the words mean in a statute. So consider the case of Collector of Customs against AGFA Gavert Limited, 1996 186 CLR 389. It's in your text. The company could import photographic paper without paying duty if it had to use a silver dye bleach reversal process. Now, the court ultimately interpreted that phrase in a hybrid manner, just to confuse things. The court held that the term silver dye bleach had a technical meaning, that is its trade meaning, and it applied the ordinary trade meaning or technical meaning in that sense. But it didn't say that the entire phrase had a technical trade meaning. So the technical or trade meaning would be read subject to that meaning, and the balance would be read in accordance with its ordinary meaning. So again, put yourself in the position of an advisor. Would you be prepared to stand opposite the client and say, well, the court will read that part of the phrase in its trade meaning and read the balance of the phrase in its ordinary meaning? Will the client understand what you're saying? And are you willing to litigate based on what you believe the court will do? And again, would you be brave enough to go to the High Court to argue that type of argument before it? These are really brave decisions made by the legal advisors that happen to pay off. The next issue relates to the question of whether we should incorporate the current meaning of words. Have a look at your text. Michelle Sanson says at page 147, the meaning given to words in a statute is the modern meaning, not the meaning of the words at the time the statute was enacted, unless, of course, the act specifically refers otherwise, or it's obvious from the context that that was what it was intended to do. So this approach suggests that the act is always speaking. Consider Justice Kirby in Coleman against Power, 2004, 220 CLR 1 at 245. Now, paraphrasing what Justice Kirby said, we draw the following conclusion or note. The purposive test is objective and is derived from the living language of the law as read today. It is not derived from the subjective intentions of parliamentarians held decades earlier, if such intentions could ever accurately be ascertained. Now, does that quote give you a bit of a headache when you're studying statutory interpretation? I have some difficulties reconciling it. And the reason I say that is that one of the mantras, if you like, of statutory interpretation is to consider the purposive test, the purpose of Parliament. We go back to the explanatory notes, we go to the second reading speech. We try to determine the purpose and intent of Parliament in creating legislation. And Justice Kirby is saying that we should consider the purposive test as objective, it's living language, it's the law as read today, and we don't look to the subjective intentions of parliamentarians decades earlier, even if we could accurately determine their intentions. So it's a bit difficult. So why do we discuss the mischief rule? Why do we consider the intention of Parliament in enacting a law as being relevant? Is Justice Kirby telling us that what we are all doing is wrong? Or is Justice Kirby telling us that the purposive test is different from the mischief rule, where there is a lengthy delay between considering a matter and the original enacting of the law in a present day case? It's a tough one. But I think what we can clearly draw from that is that we do consider that the purposive test is objective. We consider the law as it is read today. A word of warning in relation to drafting material, and this is important: using consistent terms and a consistent meaning. So where a different word is used in a place where the same word could have been used, as in a word that had previously been used by the drafter of the document, a reader is generally entitled to assume that the writer intended a different meaning. Otherwise, they would have used the same word that they'd used earlier. So think about that when you're drafting a document. Think about that when you're attacking the drafting of the document of another. In other words, if someone consistently talks about a car in a document and then suddenly switches to automobile, why did they make the change? Is there a difference? There may not be, but the assumption would be that the writer intended that there is a difference, otherwise they would have continued to use the word car. The next is limiting words. When Parliament uses words such as solely, exclusively, or only, does that mean something different to primarily? It may be a question of degree. Is it possible that solely, exclusively, and only means to the exclusion of all else, most of the time, depending on the circumstances, or always? Consider exercise 7.3 of your text. That deals with the case of Ryde Municipal Council against Macquarie University, 1978 139 CLR 633. University land is, in that case, said to be exempt from the payment of land taxes if used or occupied by the university solely for the purposes thereof, that is, for the purposes of the university. Okay. And it says used or occupied. Now, does that mean that used and occupied are meant to convey a different meaning? In other words, it's possible for the property to be used by the university and still be part of the exemption, or it's possible for the property to be occupied by the university and still be part of the exemption. Does it mean both? And it says solely for the purposes thereof. Does that mean 100%? In that case, the university leased some of its land to commercial outlets, and the court said that in doing so, the university was still using the land for the purposes of the university. Okay, now you would have read something about penditis. Cease and desist, good and ready, sick and tired. They're examples of composite phrases. If you read those phrases, you do so together. That is, they're a hendiadys. In the Victims' Compensation Fund against Brown, 2001 ALR 260, the High Court considered the expression symptoms and disability and asked itself a question. Was that expression a hendiadys, or was it meant to be not a composite expression that had one meaning only? Could the words be read disjunctively, meaning that they operate independently? So it's very important when you're drafting a document to consider those sorts of factors and be careful about adding a few extra words, which you think might be helping to explain the situation, but it may in fact be raising different questions. Questions such as, do you now mean this to be these words to be read disjunctively, or a composite expression as a hendiadys? The other trap when drafting a document is to think about the temporal expressions. A good example of that is the Jemima Gas Networks New South Wales against Mine Subsistence Board. It's 2001 HCA 19. So in that case, there was a claim for compensation, and the claims for compensation could be made in certain circumstances, but the drafting of the document perhaps was unfortunate in the sense that there is a consistent reference to material past, material present, material future within the same documentation. So it becomes confusing, and from a temporal expression perspective. So let's read what was said in the case or dealt with in the case and consider whether the terms or the words or the terms used were past, future, or present. The court had to consider claims for compensation can be made for expenses incurred, well, that's past, or proposed, well, that's future, in preventing, well, that's future, or mitigating, well, that's present, damage the owner could reasonably have anticipated would otherwise have arisen, that's future, from a subsistence that has taken place, well, that's past. So you can see that the drafter of the document has confused the temporal expressions used within that terminology. It went to the High Court, and the High Court decision was split. So the High Court struggled with this one. So what did the court decide? Well, the majority concluded, well, while there were admittedly linguistic difficulties in all the possible constructions, ultimately they considered the purpose of the provision was for the prevention and reduction of damage before it was caused. Justice Bell was of the view that the ordinary grammatical meaning of the provision confined claims to improvements after subsistence had occurred, but before the damage had resulted. In other words, from a subsistence that has taken place probably meant that the subsistence had taken place, the ordinary meaning. That's a little tricky. Have a look at that one. And use it in a couple of ways. Use it firstly as a signpost of what not to do in terms of drafting material, and also to use it as support for arguments about the use of the ordinary use of words. Now, sometimes intrinsic materials can be inconsistent or in conflict with one another. Let's have a look at one of the leading cases on statutory interpretation. Project Blue Sky against Australian Broadcasting Authority, 1998, HCA 28. So what was that case about? PBS, Project Blue Sky, challenged an Australian standard created by ABA, the Australian Broadcasting Authority. ABA required 55% of all programs broadcast in peak time to be Australian. PBS alleged that the standard was inconsistent with Section 160 of the Broadcasting Services Act 1992, which is Commonwealth, and that Act obliged Australia to comply with conventions to which it was a party, and the specific convention was the Australia-New Zealand Closer Economic Relations Trade Agreement, which was a bilateral free trade agreement. Where New Zealand service providers, such as film and television companies, should enjoy no less favourable treatment and access than Australian film and television companies pursuant to that agreement. So, how can we then have a situation occur where, on the one hand, the broadcaster should allow complete free trade between Australia and New Zealand, yet at the same time purport to oblige a broadcaster to present 55% at least of programs to be Australian programming? There's an inconsistency there. The intrinsic materials were not consistent, and they weren't consistent with each other. The High Court determined that Section 160 of the Act was the dominant provision, and Section 122 of the Act, which is the basis upon which the ABA could make a standard, was the subordinate provision. So again, that case is authority for the decision of dominant and subordinate provisions within an Act. So when faced with provisions in the same Act or different Acts that appear to be inconsistent or in conflict with each other, the Court must identify the provision Parliament intended to be dominant, which is the subordinate provision. That does mean an examination of the purpose of the Act, its overall context, including the intrinsic context, that is the statute as a whole, and extrinsic context, which is historical, political, social, and international. All right, well, good luck with your reading. We'll see you live again in week 8 on the 10th of January 2018. I'll provide you with your results for the assessment feedback soon, and all the best for the festive season. Thank you.